I'm in Hong Kong with Robert Cutler, the Chief Executive Partner of Clayton Utz, the largest remaining independent law firm in Australia. Robert, thank you for joining us today. And let's start by talking about Clayton Utz. Share with us, if you would, an overview of the practice areas, industry sectors, and locations of the firm.
Well, Ralph, we restructured in middle of last year along 14 national practice group lines. One of those is pro bono, which is very important to us and who we are, and we wanted to give pro bono a seat at our leadership table. And then the traditional areas, so corporate M&A, equity capital markets, commercial litigation, restructuring, insolvency, environmental planning, real estate, intellectual property and technology, tax, and insurance, restructuring, insolvency I've mentioned. So they're the type of national practice groups or areas in which we are. So we're a full service, top tier offering. And in the market segments in which we operate, well, obviously we're heavily involved in the energy and resources sector, right, for which Australia will be well known globally. We're heavily involved in the agribusiness sector, similarly, manufacturing, transport, and logistics, public sector as a segment. So they're across the full spectrum.
So you're across the board in the practice areas that Australian clients need,
yes,
and the industries that make the economy of Australia go.
True.
Right?
Yeah.
And the offices are all located in Australia.
They are. Oh. Every capital city bar Adelaide and Hobart. So.
Right. So we're going to talk more about that in a moment. But I want to turn now to the first of two questions about the market as a whole that I think the whole world is interested in about the way the law practice proceeds in Australia. The first has to do with what seemed like an invasion of foreign firms coming into Australia in the last few years, including very substantial combinations, including with 4 of the big 6 law firms in Australia.
Yeah.
Can you share with us your ideas, your views of how the invasion of those foreigners has affected the law practice in Australia?
I don't think it has affected the practice of law in Australia. It has added to the competitiveness of the environment. Australia has always been a highly lawyered, well-lawyered and a competitive environment. I think at the moment, over the last 5 years, since Alan Overy first set up in Australia in or about 2010, it has, and off the back of the GFC with all the cost consciousness that has flowed from that, is a hyper-competitive market. It's a buyer's market. In more recent times, with the drop in the commodity prices, iron ore and coal particularly, with the drop in the oil price, I think the heat and the level of interest from foreign law firms has diminished somewhat. I think there's a difference between the type of attitude law firms have. Some global law firms have. Some believe you must have a footprint everywhere which is a relevant market. Others will take a more nuanced view and say, well, I'll only go there if clients are telling me I should go there. So it is a hyper-competitive market, but I don't think it's, and we are competing as best we can with every law firm operating in Australia. And our vision is to be the leading Australian law firm.
So you are not experiencing an impact of these foreign firms bringing in their deeper financial resources and their global reach in competing as it happens day to day in the Australian market?
No, I think I don't think so. What has happened? The same lawyers are in the market. They have different business cards, and what the foreign, apart from some closed bonds issues very early on, they don't bring a great deal into the Australian marketplace except experience elsewhere. Now, we can replicate that through relationships with top-tier global firms with whom we have deep relationships, but who are not aligned in Australia, and do it very well.
Right. So that brings me back to where you are located, and two questions come together. How do you serve your Australian clients when their transactions, as of course they do, cross borders? And why did you, and I think you're answering this already, why did you elect at Clayton Utz not to combine with a foreign firm.
Well, if I could deal with the last question first and then circle back to, how we're responding to the competitiveness, the global competitiveness of the marketplace. Why did we decide not to merge with all the many firms who've approached us? We're always, as a firm, very cynical about the herd or the pack mentality and the lack of strategic thought that happens when there's a big bang. And there was certainly a big bang in 2010 when A&O set up. So we decided to stand back and have a look and really go and ask our clients whether they required us, saw a need for us to be a global firm. And I've spoken to many CEOs of many of our clients, and they say, no, we don't. Many Australian companies have had global relationships with law firms because they've been out of Australia for decades, if not more. They've got their established relationships with firms in other markets, be it North America, Europe, London, what have you, Asia Pacific. So nothing was going to change that. So just the fact that Clayton Utz had a new name wasn't going to change that. So we decided not to pursue a merger, but frankly to pursue deeper relationships with those global firms, with those good independent firms who, in various jurisdictions across the regions that I've talked about, those good independent, even more domestically based firms, but they have to be best in market. So our bottom line strategy is to pursue deeper relationships with best in market firms around the country in relevant jurisdictions where our clients operate, and to pursue our associations with Lex Mundi and Pacific Rim Advisory Council, and by so doing offer our clients choice, best in market choice in relevant jurisdictions, because the clients we act for buy lawyers. They don't usually buy a brand in the ordinary course. They buy expertise, and when they buy expertise, they want to know they're getting the lawyer, and therefore we want to offer them best in market choice. So that is how we're responding.
Well, this is a very interesting discussion, I think, because there are these different schools of thought at work in the world about how best to represent your clients when they go across borders, and you've shared with us a very clear explanation of how, for Clayton Utz, having a network of relationships that you can really count on with mutual dependence, mutual support will work for you.
Ralph, and I think also general counsel becoming more sophisticated in how they, sophisticated is the wrong word, but they're becoming more used to seeing teams of firms on deals, on transactions, each bringing their own competence, their skill set, bringing something to the table. And so there will always be a requirement for one invoice type, jobs. But there will also always be a requirement for top level competency and bringing together of teams. And that does not mean that it's only one firm.
That's right. I think the world is getting far more comfortable with new ideas, new solutions, and not as wedded to a single solution as they once were.
And we're joint bidding with firms, a number of firms. I won't mention them here, but on jobs in Australia and elsewhere.
Yeah. So, all right, let's turn to another subject that has been in the news around the world, and that is the decision of your government to permit outside investment in law firms, which, of course, is not permitted in most countries in the world, save in the United Kingdom. Tell us, how has that gone in the 8 or so years since it has been lawful?
I think if I had to give a reason for why it is permitted, it's generally speaking, you put it under an access to justice heading. In other words, by allowing firms, plaintiff law firms, if I talk about them, Slater and Gordon being the most well-known, if you give a plaintiff law firm access to capital, it means that they can run cases for clients without those clients being at risk or as to costs or other awards against them. They can run, and it gives those clients access to justice where otherwise they may not have been able to afford it. So that's been the bottom line rationale. How has it gone? I think it's worked reasonably well for Slater and Gordon. Some partners within that in the early days would have done very well. I think they've used the capital, not that it's a space we're in particularly, as Clayton Utz, we're not in that space. We're on the defendant side, if anything. Right. But they have used the capital to fund cases and to give themselves independence and greater choice around the search for the cases that have merit and therefore work for their business model, because they've got to have winners. The most recent one, which is of interest, is a patent attorney firm, a relatively well-known patent attorney firm in Australia, which listed late last year. It's a 22 partner patent attorney firm. None of these listed entities are anywhere near the size of a Clayton Utz or other of the big six firms in Australia. I think that is still above the listing price. So I think, and there has been, Ralph, so I got a call from Credit Suisse the other day asking me whether they could come and talk to us about it. I'm always happy to talk, but there are constraints upon us.
Right. So let's talk about that. You make a point that's very important for anyone who follows this subject, that the driver in Australia really was access to justice, and that's what it was in the UK as well, as the rationale for permitting outside investment. Now let's turn to the corporate setting, Clayton Utz and the other firms that have corporate practices. And my understanding is that none of them have yet to accept outside investment.
No, that's right.
And so why is that?
I think there are two reasons, Ralph. One is, as a corporate law firm, if I just talk about Clayton Utz as an example, we don't have an annuity type revenue stream. We have, we effectively start every financial year. Yes, there are cases and transactions which go over those financial years, but they're a shorter time frame. That puts a downward pressure on the market, the market's valuation of the business, the multiples.
The market's interest.
See, market's interest, and that means that's talking about the maths. That's an issue, how much you would get. The second issue is what you do with what you get. In other words, really you should only be doing this to reinvest, or a significant proportion of the proceeds of any float or private or other investment, into the growth of the business. Otherwise, there's no good reason. And for us, you wonder how would we use that capital to grow our business? Well, there are a few answers, none of them which apply to our strategy of being the leading Australian law firm. It would be go overseas and merge, buy open offices, hire lateral partners. Well, that's not our strategy. So those are the two constraints.
Right. Well, you make a very good point. I think a lot of the observers of this issue believe that the reason firms might accept outside investment is to put it in their pockets. And as you point out, the rationale to do it would be to make some investment for the firm into the future.
I think that's right, and I think you sympathise with this. Part of being a partnership is being a partner of a law firm is being a custodian of it for the future, beyond our time. And I think if you adopt an IPO, public listing kind of short-term view, that would potentially change. That's something to be thought about hard before any decisions were made along those lines.
Well, thank you, Robert. Thank you for spending time with us, and thank you for sharing with us your views of the Australian market and the Clayton Utz strategy. In this world of tomorrow, not one solution will fit all situations, and I think Clayton Utz's story is a very interesting one in taking a path that is different from many of its competitors. Thank you.